serious.
You are playing games, and first of all, you don't.
I'm trying to advance to
all right,
what I'm
stop.
here.
You don't interrupt the judge, whether you're a flat earther or not.
I'm not flat earth, sir.
All right, well, this crazy stuff you're saying, I've got very little patience with People versus Rosalind Ray Keenan. The allegation is that on or about May 16th in the village of White Pigeon, she did resist and obstruct a police officer and drive with a suspended driver's license. Resisting and obstructing is a felony now. It's punishable by up to 2 years imprisonment. And driving suspended as a traffic matter, punishable by up to 93 days in jail and a fine of up to $500. Carries 2 points on your driving record and requires that your license be suspended. Someone who is identified as Rosalind Keenan is present, and she wanted to explain more about that. We'll give her a chance to do that, but prosecuting attorney David Marvin is here, and he's representing the state. So let me ask you again, are you Rosalind Ray Keenan?
I'm here on as sui juris and propria persona, Rosalind Ray family of Keenan, beneficiary. Is this on record?
Yes, everything has to be on the record, so it's all being recorded.
Okay, I'm here on the special appearance, and I'm a free woman on the land. I'm here under fraud, menace, and duress. I'm the private woman, Rosalind Ray
All right.
Keenan. The all capital mentioned name is the only appellation given to me. Anytime an autograph is to be done in a certain manner that I have here, or it's forgery. Could you do this for the judge, please? That's more than enough, thank you.
All right, I'll accept this.
Thank you.
All right, so I think we have the right person here. When she signed her bond, she signed it as Rosalind Ray Keenan beneficiary with quick bail bonds.
I have spent a lot of time with her and her son, who's here. He's always been here, and they're very honest and they're good intended.
Thank you.
And I think that we've come to a resolution that I believe is fair. I've offered, I'm going to state it for the record, and only time will tell if she's going to accept it, in hopefully 2 seconds. But what I would do is offer an attempt resisting and obstructing and dismiss count 2. And instead, I would ask that the court set this for sentencing at a later date, and I'd ask for 6 months. And if by that time there's no other incidents with law enforcement or any other reason to continue, I would dismiss this, or at any time before that if I felt that it was necessary. And again, after working with her, I don't think this is the kind of thing that should be, I would hate to see this upstairs as her first felony. I think that she's interested in a way of life that she's honestly trying to understand, but I think that partly to assist her, I've kind of hatched this plan.
He is offering to dismiss the felony charge and reduce it to a charge called attempted resisting obstructing a police officer. That's a misdemeanor. It's punishable by up to 1 year in jail and a fine of up to $1,000. Do you understand that charge?
No, I don't understand the nature and the cause of the charge.
All right, Mr. Marvin, let's just do a prelim. I'm not going to tap dance with her. You may be more sympathetic about this flat earth nonsense than I am. But if I'm going to have to argue about everything from who she is to what the charge is, it'd be easier to just put on the prelim. From the affidavit of probable cause, her conduct was outrageous with a capital O. And so I'll give you one more opportunity. Ms. Keenan. Mr. Marvin is agreeing to dismiss the driving suspended charge. The record shows your license is suspended from Indiana and you don't have a valid Michigan license. That's a benefit. It won't affect your driving privileges.
Excuse me? What did you say about the,
It's a benefit. And
no, before that about the license?
he's dismissing it, and it won't affect your driving privileges here or Michigan or Indiana if he dismisses that. So he's offering to dismiss it, and that's a benefit. He is offering to reduce the felony charge to a misdemeanor, and that's attempted resisting and obstructing a police officer. If you wish to do that, we can pursue it now. If you don't, we can take testimony. The officer's been waiting here for 3 hours. What would you like to do?
Are you asking me to take a plea?
I'm asking you if you're willing to accept the prosecutor's plea offer.
Well, I don't understand that.
Mr. Marvin, let's just put on a
playing
plea.
games. I'm serious.
You are playing games, and first of all, you don't.
I'm trying to advance to
All right,
what I'm
stop.
here.
You don't interrupt the judge, whether you're a flat earther or not.
I'm not flat earth, sir.
All right, well, this crazy stuff you're saying, I've got very little patience for it. You don't have an attorney, which concerns me, because these charges could result in your incarceration. I will appoint an attorney for you. All you got to do is tell me. But you also have the absolute right to represent yourself. So, do you wish to represent yourself, or would you like me to get an attorney to assist you with this?
It's my right to appear for myself.
It is.
I don't think it would be a violation of your oath of office
To do what?
to if you did your duty under the Constitution, because I'm seeking legal intent, not advice.
Well, do you want me to appoint an attorney for you, or would you like to represent yourself?
So may I ask what jurisdiction is this, civil or criminal?
This is a criminal case, which points out the fact that you could use a lawyer if you can't tell the difference between a civil and a criminal case. Criminal case means you could go to jail, in this case, for up to 2 years. In a civil case, there's no possibility of jail. It's usually over money damages or other types of non-jail relief, like.
And my next question is, I know that the Constitution grants the court 2 types of criminal jurisdictions. One is criminal jurisdiction under common law, and the other is criminal jurisdiction under admiralty or military tribunal venue under Article 1, Section 8, Clause 17 of the Constitution. Under which of these 2 jurisdictions is the court intending to try me?
This is statutory jurisdiction of the law of the state of Michigan. It's not any of those things, including the wacky admiralty clause people try to invoke. This is criminal jurisdiction authorized by the state legislature here in the state of Michigan.
Thank you. Well, please let the record of the court show that the court intends to conduct a criminal action against me under a statutory jurisdiction. But that makes me wonder, I have never heard of criminal action under statutory jurisdiction, and there is no such jurisdiction established in the Constitution, and I will be able to proceed if you can show me where I can find the published rules of civil procedures under a statutory jurisdiction and where this nature, cause, and jurisdiction exists. It is crucial that I have the published rules of procedure so that I can conduct a fair defense and fair trial. Otherwise, this needs to be dismissed, and I would like it in writing, please.
Thank you. It's not
Thank
civil
you.
procedure, it's criminal procedure. And the defendant doesn't come up and show, court, tell me why I get to do this. You've been charged under the criminal statutes of the state of Michigan, and I've just advised you of that on the record. I'm just trying to establish at this point whether you want to represent yourself or not. As I mentioned, the conduct in here and the affidavit or the bond information report is outrageous with a capital O. And you could very well go to jail for a substantial period of time. Mr. Marvin was trying to extend to you an opportunity to avoid that option, but you're wasting all of our time with this stuff that doesn't have any legal merit. I'm offering to give you an attorney who can actually argue any legal merit or advise you or assist you in this regard. But we've had some White Pigeon police officers here on overtime for several hours. They're still waiting for you to decide what you wish to do. I haven't even gone over the first. Well, first of all, we had to establish who you were. That took much more time than it deserved. Secondly, I'm trying to determine whether you wish to have an attorney or not. Again, you do have the right to represent yourself. You wish to, but you've exhibited to me that you don't understand the law, and you're at risk of being incarcerated for this conduct.
I'm competent and I am confident. Okay?
All right.
So
The next question is, are you
Please.
willing to accept Mr. Marvin's plea offer to plead to the misdemeanor charge?
I wasn't completed with what I wanted to say to you, please.
Okay.
May I? Thank you. So I wanted to say that I don't believe it's a violation of your oath of office if you did your duty under the Constitution, because I'm seeking legal intent. Okay, so I have the right to appear for myself. In order to intelligently defend myself, I have to know the jurisdiction this court is operating under, because the rules of civil procedure under common law jurisdiction are very different from the rules of civil procedure
All right,
under
stop.
admiralty or military
Stop.
tribunal venue.
Stop. We went through this before.
I know.
This is not civil
It's the
procedure.
Sixth Amendment grants me the right to know the jurisdiction being applied,
And I told you what it was.
and it gives you the duty.
All right, stop. If you interrupt me one more time, I'm going to find you in contempt and you're going to go to jail. And
Objection, please.
all right, please.
Please.
We're going to
sir,
talk
may
about
I?
this
The
tomorrow
contempt.
at 3:00. I find that you're in contempt.
I
You're
do
going
not
to
wish to
jail
be
right
held in
now,
contempt,
and we will.
sir.
Well, you have been.
I'm simply
matter
trying
is
to
adjourned until
exercise
tomorrow
my
at
Sixth
3:00.
Amendment rights, please.
So you can think about
And
it
we can go
overnight in
forward
jail.
with this right now, please.
No, you're
I-
going to
I do
jail
not
for
wish to be in
24 hours.
contempt.
I know you don't wish to go to jail, but you certainly
I
have
will
earned it.
continue with this if you'll please let me finish.
We'll talk about it tomorrow at 3:00, and you will be more respectful to the court.
I
You
can
will speak.
provide the
You will not interrupt the
citations.
court. Your citations are meaningless.
I'm sorry I
So you
interrupted
can
you.
go
If you want to
with the
continue-
officer. I don't want to argue about it. Take
I'm
her
not
out of here. We
arguing.
will address this tomorrow at 3:00.
Stand up and put your hand.
No,
I can't get her aspects because they're.
they'll get them for you. You can give all the paperwork to him.
Thank you.
Mr. Marvin, I don't know what you've got tomorrow at 3:00, and I don't know what I have, but we'll take another shot at this tomorrow.
Justice takes time.
Just misunderstood.
Yeah, I don't know what's going on, and I don't think this was a fair trial,
We haven't had a trial yet.
a fair preliminary.
We didn't even get there yet.
Please be careful with this one.
Yep, absolutely. There we go. Yeah. Okay, we're gonna go over here, Ms. King. Yep, I'll get all the property for you. I'll go right over here.
Here, fill my pockets. Please.
Listen to the office. Yep, I will get all the property from you, ma'am, and whatever property you want to release to your son, I'll be more than happy to. She's going into custody for contempt.
Let's go this way.
And then watch out for this chair here. There we go. Go ahead and watch your foot. There we go.
So, that's it, then it's court over.
Yeah, we're done.
Can I say something?
Yes?
I don't think that she was trying to be in contempt of court, she was trying to exercise a right. And I think it was just a misunderstanding of how for her to be able to pronounce that, but,
Well, I told her to stop and she didn't stop, and she doesn't know what she's doing. She needs a lawyer, and she's gonna contempt herself into 90 days if she doesn't be careful. So we'll address this tomorrow at 3 o'clock, and to whatever extent you're advising her on this stuff, you're not doing her any favors. Mr. Marvin gave her the sweetest deal where she could not have a charge on her record, and all she wants to do is argue about admin. Ms. Keenan had previously indicated she did not wish to have an attorney, and there was no attorney on her behalf at that time. Prosecutor David Marvin was here yesterday, and there was one or more police officers that were here yesterday prepared to testify. We didn't get very far. We started to go through the particulars, but Mr. Marvin made a plea offer. I want to repeat that, Ms. Keenan. He offered to dismiss the felony charge of resisting and obstructing. He offered to dismiss the charge of driving suspended, which would not go on your driving record, for a misdemeanor plea to attempting to resist or obstruct a police officer. That's a misdemeanor. It's punishable by up to a year in jail and a fine of up to $1,000. He offered to then defer the sentence for 6 months. And if there were no other issues or concerns, he would consider dismissing the case. He was not able to be here this afternoon. He stopped in this morning and confirmed to me that his plea offer was still open to dismiss the felony charge and the driving suspended charge for the plea to attempting to resist or obstruct a police officer. We were talking with Ms. Keenan yesterday. I found that she was in contempt and ordered that she go to jail, and she did, and we're here today. We were trying to establish whether she wanted any legal assistance in this matter. So, Ms. Keenan, you're the same person that you were yesterday with the same reservations and concerns. Is that correct?
I have some things, like proof that the license shouldn't have been suspended, and they did reinstate them in Indiana.
All right. Well, he's willing to dismiss that charge.
I think that's why, because I showed it to him.
All right. Well, maybe so. He said you and he had several discussions. So let's see if we can get to square one here. Do you want an attorney to assist you in this matter? I can appoint one, and we can set it for further hearing. I don't want to force one on you, but I do think you could benefit from having counsel. It was clear you didn't understand the difference between a criminal case and a civil case, and you contempted yourself into a day in jail. I won't be offended if you tell me that you want to have an attorney, in which case I would set this matter for further proceeding out 2 weeks, which would be July 5th. How would you like to proceed, Ms. Keenan?
Thank you. So if I choose to get an attorney, I have 2 weeks, and then nothing else will be brought up today. Because
Correct. Now, you could enter the plea to the misdemeanor offer that Mr. Marvin made today, but I do think you could benefit from having an attorney to assist you with this, in which case I would continue it to the 5th of July. That's 2 weeks from today in the afternoon. Usually it'd be on a Tuesday, but that's a holiday. It would be 1 o'clock on July 5th.
Am I going to be still having to stay at the county jail and wait till?
Well, let's talk about that. No, you posted a $10,000 cash or surety bond. However, you've not agreed to be fingerprinted. So as soon as you agree to be fingerprinted, you can be released from jail. Otherwise, you're going to sit there for 2 weeks.
Okay.
All right. Would you like me to appoint an attorney for you?
Yes, if you appoint an attorney,
Mhm. Go
they're
ahead.
defense attorneys.
Yes,
Okay.
here's your son. All right, I'm going to appoint an attorney, which I think you could benefit from. I guess you can always say later, I don't want one, but at least like you have an opportunity to consult with one.
I have a question too.
All right,
If I have an attorney, I would like to be able to not be able to see him any sooner than Friday, because I want to be able to go
that's fine.
to a couple appointments for my dental and things that I want to do.
I'll give you their name or number. It could be a he or a she. Continue to July 5th at 1 o'clock for prelim. Bond is reinstated.
You mean that the bond was canceled?
No, it wasn't canceled.
Oh,
Under condition, a defendant be fingerprinted. The original complaint from the day of the arrest said that you did not comply with fingerprinting at that time. They attempted to do the fingerprinting again yesterday and they weren't able to do it. And I was advised by corrections staff that as of today, you've still declined to be fingerprinted. So as soon as you agree to be fingerprinted, you can get out. If you don't, you can sit there for 2 weeks and we'll discuss it next Friday, on July 5th. In the meantime, I believe Mr. Marvin's misdemeanor offer is going to remain open, but you're not to be released until you complied with the booking process, including photo and fingerprints.
excuse me.
Yes, sir.
Today
Yes, ma'am.
I think it was today or maybe, because I slept a lot, so I don't even, anyway, they booked me and took my picture.
All right, well, the
Is that
picture's
good
done.
enough?
That's good enough, but you
That's
have to
good
agree to
enough?
the fingerprints.
Oh, I still have to do the
Yes.
fingerprints?
And you can decide whether you want to do it. If you don't, that's
Well,
up to
I'm
you.
gonna do it
All right.
because I appreciate your offer. Thank you.
All right, they'll take you back to the jail. If you finish the fingerprint process, you can pick her up at the jail. We'll give you the paperwork before she goes about who her court-appointed attorney is. After Friday, I want you to call them and make an appointment to discuss this matter with them. All right, good afternoon once again. Are you Rosalind Ray Keenan? This is file 23915FY. Ms. Keenan is charged with resisting instructing a police officer and driving suspended. That allegedly occurred in the village of White Pigeon on May 16th. The defendant was arraigned on this. We had some discussion and I encouraged her to get an attorney to assist her with that. And she was not really in favor of that. But I said, well, let's appoint an attorney. You can discuss it with him and then determine how we want to proceed at that time. Ms. Keenan, resisting instructing a police officer is a felony. It's punishable by up to 2 years in prison and a fine of up to $2,000. The driving charge carries 2 points, up to 93 days in jail, and a fine of up to $500, and it requires that your license be further suspended. When we were here earlier, Mr. Marvin had made what I consider to be a very generous plea offer, but we weren't able to get to that point. And so the matter was set for a preliminary examination today. A preliminary examination is a hearing where it must be established in order to go forward that there's probable cause to believe a crime was committed and probable cause that you did it. So I'll defer to you, Mr. Bush. Where are we here today?
Well, there's a number of issues for the court to hear. Ms. Keenan is asking for a 30-day adjournment so she can review the discovery. I believe she's been provided with most of the discovery, but that is her request. There is
Mr. Marvin, are there video? or dash
Everything
cam?
that I have, she has.
Including video?
Yes.
Okay,
I don't know that she may have. I have it.
okay.
Put it that way. There's a very short police report and some audio-visual evidence.
All right. Ms. Keenan, is that true? You're going to ask to adjourn this matter 30 days?
I was asking, requesting that from him.
Okay. Well,
I put it in writing in an email and asked a few things, but
well,
And I told her that I would make that request.
I mean, we just met and we really haven't had a chance to go through any of this.
Mr. Marvin, what's your thought?
First of all, I just want to make it clear that the offer is still available to resolve this. I do have a problem though with pulling Officer Hanson off the job as many times as we have. This has been, I'd say he's spent at least 4 hours sitting here waiting for these, and it's been one adjournment after the next. I don't know what a 30-day adjournment would do. I don't know for what reason. There's nothing that I could see that hasn't been explained. I don't know if it's going to do anybody any good. I think we're going to be back in the same boat.
Well, we may. Yeah, I felt your plea offer was very generous. It would result essentially in no conviction,
That's right.
and it would take the driving charge away.
Yes, and also I recently found out that that's been restored anyway. So part of my offer was get that restored, and then I will. There'll be a plea to a attempt R&O, and then that will be dismissed if there's smooth sailing for. I would ask for about 6 months, but at any time before then, I planned on dismissing this.
Miss Keenan and I had a pretty animated discussion the first day. And then the second day, it was much more subdued, and I encouraged her to get an attorney to help her. She has a profound misunderstanding of how Michigan law works, both in the criminal code and the traffic code. I refer to these people as borough groves. They're commonly referred to as sovereign citizens, but I don't find any sovereign in it. She certainly is a citizen. So, Miss Keenan, I don't know enough about this. I wasn't there. You were there, and you experienced what you experienced. Apparently, there's video of it. Mr. Marvin has offered for a plea and a deferral and a dismissal. I am pleased to hear you have your driver's license back, so I won't be dealing with that issue in the future, but you were allegedly suspended at the time of this. If you get convicted of the driving suspended charge, it's going to undo what you just did. It's going to take your license away. And Mr. Marvin's not really looking for that, but that could be the result of this.
I asked for a 30-day continuance so that I could put things together to defend my rights, to defend myself, not to excuse anything else, but to.
Do you want Mr. Bush to represent you in this matter?
I have been wanting to, but I want to be able to get to on some issues.
Well,
today.
And I envisioned that whoever got appointed to this would clash with you because you have, and I can't tell whether these are sincerely held beliefs or just part of a contrary lifestyle. Whoever is providing you with this information, as I said, isn't doing you any favors. And I'm not even sure the people that in fact, I doubt that the people that originally this stuff even believe it. It's so nonsensical. Admiralty law and code of civil procedure and things that just didn't apply to this. But I do apologize. Officer Hanson's been here multiple times. But if 30 days could help resolve this rather than bind this over to circuit court on a felony charge, maybe it's worth it. Let's see, Mr. Bush, when your next duty week is. Now, you can hire a lawyer if you wish, but I don't think you're going to be able to do that. You're not going to be able to pay anybody money to try to provide the defense that you want. They just will decline to accept you as a client because they don't need that aggravation. In fact, I would be amazed if you could find somebody that you could hire that's a licensed attorney in the state of Michigan that would pursue the kind of defenses that you want. Plus, you don't have a lot of money, and so you're eligible for court-appointed counsel anyway. But I would tell you to go hire your own lawyer. We're not going to be able to find one. And if I appoint someone other than Mr. Bush, you're going to have the same issues you have with him that you're having with Mr. Bush. I'm going to continue this for a prelim. How about if we set a pre-exam conference so we don't have to drag Officer Hanson in here?
That's reasonable. If you just set it on my duty week for pre-exam.
Well, the problem is your duty week isn't way until the end of September.
I don't know that, Judge. I'm sorry.
You don't have another duty week till December 25th. That's why I'm going about 30 days. I'll set a pre-exam conference for August 15th at 8:30. That way you don't need a subpoena, don't need to drag Deputy Hanson in here. If the matter is resolved, we can deal with that. If it isn't, we can schedule a preliminary examination at that time. So we'll leave it at that. Do you have any questions you want to ask at this time?
You're continuing it then?
Yes, I am. I've granted
Thank
your.
you.
All right, I'll just leave it at that. All right.
By the time this case reaches its final moments, one truth stands out clearly. This was never only about the charges. It was about whether the system itself was understood. Again and again, the court laid out options: a lighter charge, a chance for the case to disappear, access to a lawyer, and in the end, the defendant finally agrees to legal help, a move that may shape everything that follows. Because the reality is this: the legal system runs on fixed rules and strict procedures. You don't have to believe in them, but if you fail to understand them or choose to fight against them, the consequences can spiral fast. This case shows how not understanding the law can be just as risky as violating it. So now the question is yours. Was this a stand on principle or a serious misunderstanding of how the system truly works?